All right, I think we are ready to start. Good morning, everyone. Good afternoon for those of you who are joining us from Europe. I hope you're all well. Again, I want to remind everyone that we have interpretation available today. So if you do want to use this function, please just try to locate the icon, the globe icon with the name interpretation on it, and you'll find two channels, Spanish or English. Just select your language of preference and stay in that channel. Thank you so much. So it is a pleasure to be with you today. My name is Isabel Roby, and I am the Latin America staff attorney at Robert F. Kennedy Human Rights. Our organization has co-organized this event with the International Commission of Jurists and Fair Trials. And today I will be moderating this event together with Carlos Luzberti from the International Commission of Jurists. The main aim of this event is to highlight the human rights situation in Venezuela, particularly related to the failure of the justice system to protect and the recurrent human rights and due process violations in the country, ahead of the Universal Periodic Review of Venezuela before the United Nations. For those of you who are not too familiar with the term, the UPR is a process that involves a review of the human rights records of all UN member states. And next week, on January 25th, after 6 years, Venezuela will face another review before the Human Rights Council. For this reason, we thought it was very important to organize a space where we can hear directly from civil society organizations in Venezuela about the current situation. As many of you know, Venezuela faces an ongoing political and socio-economic crisis that dates back to at least 2014. Political repression, restrictions on civic space, widespread human rights violations, and the region's most significant ongoing economic and humanitarian crisis, which have caused, according to the UN updated figures, nearly 6 million Venezuelans to flee abroad. Moreover, just last year, the UN fact-finding mission on Venezuela not only found reasonable grounds to believe that crimes against humanity had been committed in the country, but it also confirmed that the Venezuelan justice system has served as an instrument of repression, providing legal covers for human rights abuses, including extrajudicial killings, torture, sexual violence, and enforced disappearances, among others. The mission also warned that said crimes will go unpunished if alternative means to justice that do not go through state institutions are not sought. Additionally, the prosecutor of the International Criminal Court opened an investigation on crimes against humanity committed in Venezuela, offering a path for some measure of individual accountability and justice for victims. It is within this context that Venezuela will face its Universal Periodic Review. And through this event, we want to offer a space to civil society organizations to give us a firsthand account of the situation as Venezuelans continue to struggle to reclaim their democracy and their most basic fundamental rights. Now, I would like to express our appreciation to the three organizations joining us today, which include Foro Penal, Defiende Venezuela, and the Centro de Derechos Humanos de la Universidad Católica Andrés Bello. Each organization will have 15 minutes to present their overviews and findings. Then we'll have a follow-up question for each of them. And at the end of all the presentations, we will allocate some time, at least 20 minutes, for questions from the audience. So please feel free to send your questions in the chat or the Q&A function. And finally, I have the pleasure to introduce you to our panelists. We are kindly joined today by Alfredo Romero, who is a human rights lawyer and activist in Venezuela and the director of Foro Penal, and also the 2017 Robert F. Kennedy Human Rights Award laureate. Mariana Romero, who is a lawyer and the director of Centro para los Defensores y la Justicia and the academic coordinator at the Centro de Derechos Humanos, UCAB. And finally, Ezequiel Monsalve, a lawyer at Defiende Venezuela. He has a master's degree in criminal law and criminology from Universidad Católica Andrés Bello and a master's degree in criminal justice from Universidad Carlos III de Madrid. And now, without further ado, I will pass it on to our first speaker, Mariana Romero from el Centro de Derechos Humanos UCAB. She will give us an overview on the fracturing of Venezuela's judicial system and the separation of power as a threat to the rule of law.
Thank you, Isabel. Good morning and good afternoon to all who join us today. Hope everyone are well and in good health. Before I start, I want to thank the ICJ, Fair Trials, and the RFK Human Rights for the space to share with you the main concerns of Venezuela's civil society regarding the failures of the justice system in Venezuela and its impact on human rights. On this occasion, I will refer to the fracturing of Venezuela's judicial independence and separation of powers as a threat to the rule of law. To understand the reasons why there are serious and systematic violations of human rights, many of which are even configured as crimes against humanity in Venezuela, we must start by knowing and understanding the socio-political context and the different dynamics that take place in the country. Mainly the deficiencies in the protection that the justice system and even the whole state institutions should provide to the population, which in principle must ensure the respect for democratic principles and the rule of law. This situation is the origin of the abuses against fundamental freedoms, violations against human rights, and those crimes against humanity that have been committed over the years in Venezuela, either by actions or by omissions carried out by the different actors with power and the government structure that facilitate or encourage such transgressions to occur. So, as I meant, by action or deliberate omissions, the institutions in Venezuela are responsible of the human rights crisis. According to the international standards, according to human rights international law and international criminal law. And since 1998, with the arrival of the Chavismo in power, it will be possible to observe how in the last 23 years, Venezuela has experienced a process in which through different measures, legal, administrative, and factual measures, a state policy of repression, criminalization, and social control, and also discrimination and persecution for political reasons has been established by adapting the entire institutional system to convenience of those who hold the power and limiting any possibility of independence of the different powers of the nation, avoiding checks and balance between these powers. Systematically, the human rights in Venezuela population have been seriously affected by the implementation of the different authoritarian measures which were created and progressively perfected in order to facilitate the permanence in power of those who today exercise the functions of the executive. The institutional cooptation of has been the starting point for the existence of a context contrary to the protection, respect, and guarantee of human rights in Venezuela. Also, thanks to the erosion of the institutionalism in Venezuela and the lack of independence of powers, those human rights violations were facilitated in order to fulfill the interest of the executive power. For example, the legislative powers through the National Assembly has been used to legalize repression, criminalization, and social control, thanks to the promulgation or modification of criminal law and administrative norms that have been served to persecute and to repress. For their part, the judiciary and the citizen power made up of the office of the general attorney and the office of the ombudsman have served as the executing arm of the repression, both by action and by omissions on its duties. Those acts occur in a framework of institutional cooptation, so the lack of effective public policies and problems associated with corruption result in Venezuela being immersed in a complex humanitarian emergency of a multidimensional nature. And as a consequence of the lack of solid, independent, and impartial institutions that assure the respect, protection, and guarantee of the human rights of the population, day by day in Venezuela face more reductions of the civic and democratic space, and that contribute to increase the abuses and to facilitate the impunity on human rights violations. So it has been observed that the actions of those who hold power are part of the strengthening of state violence in an increasingly lethal manner, and the implementation of those social control measures and mechanisms applied in order to consolidate the authoritarianism regime in order to permanence in power through force, oppression, and fear of the population. In the last 4 years, institutional cooptation has had a greater impact on human rights violations. Thanks to the entrenchments of authoritarianism, public powers have had a greater role in human rights violations, especially in repression and criminalization of opposition political leaders, peaceful demonstrators, journalists, trade unionists, human rights defenders, NGOs, and humanitarian organizations, or even in any person who promotes or demands the vindication of rights for being considered dissidents and consequently seen as enemies of the state and of the national security. This was widely documented by the International Fact-Finding Mission in Venezuela, in whose last report it is precisely accounted in detail, especially how the shortcomings in the justice system have contributed to these violations and especially to their impunity. Also, the situation and the evolution of the lack of independences of power and its impact on the erosion of the rule of law has been widely documented over the years by international mechanisms such as the Office of the High Commissioner of Human Rights, the special procedures of the Human Rights Council, the organisms of the Inter-American System, and many international and national human rights organizations. Part of these violation patterns has been, for example, the temporary nature of the judges and prosecutors who are also subject to undue pressures to act in one way or another according to the interest and superior or external orders, mostly from the executive power. The use of a special courts for the persecution of dissidents is other of the patterns, such as those with jurisdiction over terrorism, as well as the use of military justice to pursue criminalization of civilians. Violations of due process, ranging from undue delays on trials, arbitrariness when deciding, denial of procedural principles, denial of justice, among other are also examples of that violations. On the other hand, in an authoritarian regime, as a result of the pandemic, Venezuela's state increased its de facto powers, contrary to the constitution itself. contrary to the international recommendations, in order to strengthen the control by taking advantage of the global crisis. Thus, in recent years, new violations associated with procedural delay and greater use of the justice system in the execution of the state policy of repression, criminalization, and social control have been documented by the NGOs in Venezuela. The state has made use of the state of alarm and emergency states to discretionally increase its powers against constitutionally since 2016, with the validity of a supposed state of alarm and economic emergency that was justified precisely in the protection of the sovereignty of allegedly internal and external enemies who sought to destabilize the country. The rule was enforced unconstitutionally until begin 2021, and from March 2020, along with a state of alarm due to the COVID pandemic, and this, as I said, led to greater authoritarian controls, repression, and social control. To conclude, I want to highlight the tightening the grip on power as a response to current economic sanctions. The state has attempted to justify and attribute the responsibility for human rights violations to sanctions. However, the more than 90,000 protests documented by Venezuelan Observatory of Social Conflict in the last 10 years, the majority of those demanding the protection of economic, social, and cultural rights, 1,181 attacks on human rights defenders and human rights organizations in the just last 3 years, according to figures from the Center for Human Rights Defenders and Justice, the thousands of extrajudicial executions registered by organizations such as Provea and other NGOs in Venezuela, the arbitrary detentions, political prisoners, victims of torture, and those are clear examples that full responsibility for human rights violations falls into the Venezuelan state, thanks to its lack of interest in providing justice and to generate effective mechanisms so that these violations do not continue to occur. Thank you very much for your attention.
Thank you so much, Mariana. We truly appreciate your presentation. Now, I would like to follow up with one question. And according to what you already said, and what civil society organizations also sent to the UPR, the justice system in Venezuela ceased to be independent, and the rule of law changed to a de facto militarized state. The lack of independence has contributed to prosecutors and judges participating directly in serious human rights violations. And my question would be, is there any hope for a transition to take place and a recovery of the rule of law and the justice system to occur? And if so, what do you think will be the essential elements of it?
Thank you, Isabel, for the question. Very important facing the current situation with the justice system in Venezuela. I think that the eventual establishment of a transitional justice system in the country, in order to guarantee that true justice, reparation, and in particular, the establishment of measures for the non-repetition of these human rights violations, to be really achieved, it will be necessary for all the actors involved in this eventual process to take into account the importance of the reinstitutionalization of all the public powers in Venezuela. Since if the structural problems are not addressed, which, as I mentioned in my intervention, have allowed and facilitate commission of human rights violations, it will be very difficult to move towards a recovery of the rule of law and democratic principles. In this sense, a transitional justice system need to have to provide jurisdictional and institutional guarantees to reparate the damage caused by the violations and to create effective measures for the full and effective enjoyment of all human rights in Venezuela. And the basis for this, it should be the reform of the institutions and fundamentally to recover the confidence in them. And to achieve that, it will be very necessary to strengthening the independencies, and that will be crucial. Thank you.
Thank you so much, Mariana. We will most probably get back to that point at the end when we have our Q&A sessions. Thank you so much again. Now to continue this discussion, I would like to pass it on to Alfredo Romero from Foro Penal. He will give us an overview on due process violations and the use of the justice system as a tool for political persecution.
Thank you, Isabel. Well, my name is Alfredo Romero. I'm the president of Foro Penal, which is an NGO that has been working for almost 20 years in Venezuela, representing pro bono victims of political repression in Venezuela. As Mariana said, it's not just to talk about a failure of the justice system in Venezuela or even a due process violations. It's more than that. I mean, the key issue here is a systematic use of the judicial system as a tool or as a weapon for political persecution and for political control, of course, and for exclusion also of opponents, and to eliminate or to stop protests in Venezuela. That is the key point or the key issue to understand the whole situation. At this moment, I want to talk about some specific facts just to give you a general idea of what is going on. At this moment, there are 245 political prisoners in Venezuela. But it's not just that number, the important one. The important number is almost 16,000 people that have been incarcerated since 2014 for political reasons. This is what this is important, what I have called the revolving door effect, that even though there are 245 political prisoners at this moment, maybe next week there will be 240, and maybe the other week will be 260. But what happened is not that they are the same people. So they incarcerate some and they release others. And at the end, the important number in order to understand the intimidation effect of imprisoning people for political reasons is almost 16,000 people that have been in jail at some point. Another important issue regarding the political prisoners or political detainees is that they are not, at this moment, for example, they are not political activists in jail. And this is also important because when you talk about political prisoners, people that they don't understand the concept, they believe that they are political opponents or political activists or political leaders. No, they are human rights defenders, they are students, they are journalists. There is, for example, the case, one important case right now in Venezuela of Javier Tarasona, who is the president of Funda Redes, an NGO. And just to give you an idea of how they use the political system or the judicial system to persecute, for example, civil society. This is a good example. Why he's in jail? He's in jail because what they accuse him is promoting hatred. And what is, according to a law, the law against hatred, what we have right now in Venezuela, which is an unconstitutional law, whatever. But the thing is, why he's being accused of promoting hatred? Just because he denounced officially before the prosecutor office in Venezuela that some paramilitary groups at the border in Venezuela were committing human rights abuses in combination, supposedly, with the official armed forces. He denounced it officially before the prosecutor office in Venezuela, and he was detained inside the prosecutor office in Venezuela because of promoting hatred. And this how they use the judicial system. Another thing is that, of course, the government will tell you, if you ask about political prisoners, that they are not political prisoners, that they are some people that have committed crimes, that they are criminals. But just to, I don't have to explain every situation. Just I will give you a specific information how to refuse or how to oppose to this specific affirmation. Well, of those 245 political prisoners, 210 are on pretrial detention. I mean, they haven't been sentenced. Just 35 of those political prisoners have been sentenced. So they are not, they don't have a due process of law. They haven't had a chance to defend themselves. 91 of these 245 political prisoners have been more than 3 years in prison on pretrial detention. And 59 of those have been more than 2 years in prison on pretrial detention. And according to the Venezuelan Criminal Procedure Code, the maximum time that someone can be on pretrial detention is 2 years, with an exceptional extension of 1 year more. So the maximum is 3 years. And you have 91 people arbitrarily detained without an excuse, without a possibility of a trial, and with when you talk to a prisoner in general, the worst thing that can happen to them is the uncertainty of knowing how long they will be in prison. I will give you the example of, for example, Jose Gámez Bustamante. Jose Gámez Bustamante is a military accused of a conspiracy in 2015 on the context or within the context of protest. Well, he's been 7 years in prison on pretrial detention. So he doesn't even know formally what is the reason why he's in jail. He hasn't had the opportunity to defend himself, and he's in jail. So there is no, I mean, even though if the government say that they are criminals, they are using, again, this specific tool for what a specific reason. There are two objectives of having, and this is an intentional thing, of having these people on pretrial detention. The first one is torture. I mean, when you have the uncertainty of knowing how long you will be in jail, this is a kind of torture method. But another one, which is a more technical objective, is to oblige these people to admit crimes. Actually, of those 35, just 35 of the 245 political prisoners have been sentenced. Of those 35, 12 of them have actually admitted crimes without being responsible for that crimes. And that's something that is happening, and they put pressure on them to admit crimes. Why? Well, because they want to present you, the international community, a kind of rule of law facade saying, okay, they are not political prisoners. They are people that have committed crimes. Well, they have admitted crimes, so they're responsible for that without even having a trial. And another important thing is something that happened last year. Just on last year, 3 political prisoners have died in jail. Since 2014, 11 political prisoners have died in jail. Why they have died in jail? Well, because they don't have medical attention. There are cases at this moment of people almost dying because of lack of medical attention, and they don't care about it. There is a case, for example, of Mirlendris Benitez. She's a woman. She's been more than 3 years in jail. She's been tortured. She was forced on an abortion because of torture or cruel treatment, and she's sick, and she's in jail. And I can tell you that there is a very important risk of she can be also died in jail. And this is a mechanism that's being used to intimidate people. It's not just being detained. It's also torture that is being involved. Just to finish, I will conclude with, within all these 3 political prisoners that died last year, there is also an indigenous guy, an indigenous man. His name is Salvador Franco. He died on January the 6th, and he was in jail because of also this problem that is going on with the Arco Minero, with the gold exploitation that is going on in Venezuela, and they are also killing or persecuting indigenous people. I will finish with what already Isabel said at the beginning, which is extremely important. Venezuela, and maybe these are ironic what I'm going to say, but Venezuela have the medals of human rights abuses. It's an exception. Venezuela is an exception in the world because we have, first of all, we are the first and the only country in the Americas that an investigation has been opened by the prosecutors of the International Criminal Court for crimes against humanity. This is something exceptional, but Venezuela has it. Another thing is we have a fact-finding mission on Venezuela investigating human rights abuses. And if you read these reports, you have detailed information about what we are talking about today. We also, as a third medal, we have representatives of the Office of the High Commissioner for Human Rights in Venezuela, reviewing or following the human rights abuses that are happening. Thank you very much.
Thank you, Alfredo. And yes, you mentioned the case of Javier Tarasona, which is one human rights defender criminalized in Venezuela, which is one of the one emblematic case or and very good example on how the Venezuelan government is repressing and acting against the opposition, the human rights activists, and the civil society. Under the current activities of Foro Penal, I was wondering, and as a follow-up question, could you please maybe comment for us how has been the work of the lawyers? For example, if you have been facing barriers, especially under the current circumstances of the pandemic for COVID-19, for example, in Venezuela, the courts and tribunals were closed for 7-8 months, and this last 10 months or something like that has been working 1 week open, 1 week closed. Maybe you can share with us how, what kind of barriers the lawyers are being confronting during this period, and of course previously, especially on your role as human rights defenders.
Yeah, thank you, Carlos. Yes, if you talk about barriers, I mean, there are many. We are not treated at the courts as lawyers. Actually, we're treated sometimes as enemies. I mean, as some people that are coming and they don't like us. This is something that you can feel it. Even though that we are more than 5,000 activists right now in Venezuela. There are more than 500 lawyers working all around the country. So we, even though there are barriers being imposed in some way, practically, we have some, connections with the courts, and we can still at some point represent these people that we represent. However, barriers, as you said, have increased in last years. as you can maybe hear, or we have denounced many times, it's more and more difficult to access the courts in order to being designated as a lawyer, as a private lawyer to these people that we represent. The case you talk about, the case of Javier Tarasona, they didn't allow us at the beginning to represent him. We were more than 3 months denouncing nationally and internationally that the court didn't allow us, the judge didn't allow us to represent him. Actually, Michelle Bachelet in one report last year actually talked about that and asked the Venezuelan state to allow us to represent specifically Javier Tarasona. Didn't allow us. Just at the end of November, he was detained in July 2021. Just at the end of November, because of all these denounces and many things that we did, is when they allow us to get into the court and represent Javier Tarasona. It is more and more difficult to visit these political prisoners. You talk about the pandemic. Well, because of the pandemic, we were more than a year without the possibility of talking to them personally or visiting them, even the families or us. So it was, of course, a violation of the right of defense, because we couldn't talk to them, we couldn't defend them, there were no trials. So in some way, we believe they will using the pandemic in order to keep them detained without trials and without the right of defense. And of course, it's something intentional, because now that it's been more open regarding to the pandemic, they still put barriers to in order to represent them. At this moment, right now, Javier Tarasona, we represent Javier Tarasona. I'm personally is being designated as a lawyer of Javier Tarasona, and I haven't had the opportunity, or they haven't allowed me to visit him in his prison center. He's at the Helicoide. Right now, he's been almost 6 months, and I haven't had the possibility to visit him. And why is it important to visit him? It's not just as I want just to visit him. It's because this is the only way that you know the facts, you have a conversation in order to know what happened and actually to represent him in an effective way.
Thank you so much, Alfredo. We want to remind the people who is attending to this seminar that we will allocate some additional time for a session for Q&A at the end of the presentations. And now I want to keep the discussion and pass the use of the floor to Ezequiel Monsalve. Ezequiel is a member of Defiende Venezuela, which is another NGO which is in Venezuela in the ground working for human rights, as Isabel mentioned in the presentation, who will give us an overview of the failure of the Venezuelan justice system to protect fundamental rights. Defiende Venezuela has been working, for example, on litigation of some economic, social, and cultural rights, and how the court has been unable or incapable to protect those rights of the population in the middle of the complex humanitarian emergency in Venezuela. So, Ezequiel, adelante.
Hola, ¿qué tal? Muchas gracias. Buenos días a todos. Saludos extensivos a los compañeros panelistas y amigos de las organizaciones de la sociedad civil en Venezuela. Yo creo que el panorama que presentó Mariana y Alfredo es un panorama que es real, que existe, que es la dinámica actual del sistema de justicia venezolano, y hace que justamente esa dinámica limite las posibilidades, anulas, ¿ok?, de proteger los derechos humanos, o sea, que sea ese mismo sistema de justicia que proteja los derechos humanos. Por esa razón, organizaciones como Defiende Venezuela, Foro Penal, entre otras, han tomado la decisión de hacer incidencia o trabajar casos de litigio internacional hasta instancias internacionales a los fines de proteger los derechos humanos que en buena parte el Estado venezolano no lo puede hacer a través de su sistema de justicia. Empecemos con un razonamiento que es lógico, conforme a lo que mencionaban los panelistas, y que esto fue certificado en el segundo informe de la misión de determinación de hechos, y también había sido advertido hace muchísimo tiempo por otras organizaciones y miembros de la sociedad civil en Venezuela, que justamente el rol que sostiene el sistema de justicia venezolano en su vinculación con la comisión de graves violaciones a los derechos humanos, y muy recientemente incluso en la comisión de crímenes de lesa humanidad. Es decir, entender que un sistema de justicia se comporta de esta manera nos arroja como conclusión que es inviable, que es improbable y que es inverosímil que sea este mismo sistema de justicia que proteja los derechos humanos. ¿Ok? Incluso la misión de determinación de hecho así lo afirmó, cito en palabras textuales, diciendo lo siguiente: el Poder Judicial no ha actuado como control de los demás agentes del Estado, perpetuando la impunidad de los crímenes cometidos. La mayoría de las violaciones y crímenes documentados por la misión no ha dado lugar, a investigaciones exhaustivas, procesamientos y condena de los presuntos responsables. Por lo tanto, para la misión de determinación de hechos, hay motivos razonables para creer que estas omisiones se vieron afectadas por la falta de independencia judicial. La participación, un poco para entender lo que sería la ausencia del sistema de justicia en la protección de los derechos humanos de las personas en Venezuela, muy particularmente de los ciudadanos venezolanos, son tomadas de dos informes que hizo Defiende Venezuela el año pasado. El primero lo hizo junto a la Universidad de los Andes y la Fundación para el Debido Proceso. Se tituló Acceso a la Justicia, Erosión a la Autonomía e Independencia del Ministerio Público e Impunidad en Venezuela, donde se da un panorama de la falta de independencia en el ejercicio de su cargo de los fiscales del Ministerio Público, que como sabemos en Venezuela tienen el rol de la titularidad de la acción penal, de dirigir y liderar las investigaciones en Venezuela, dado el procedimiento acusatorio que tiene el sistema penal venezolano. Y en segundo lugar, el segundo informe que se presentó en este ciclo de sesiones de EPU fue el reporte de torturas que se hizo junto a la organización Sin Mordaza en julio también del año pasado. ¿Cuáles fueron los principales puntos que nosotros podemos extraer de estos informes y recomendaciones que se hicieron estos informes a los estados? Básicamente tres, dirigidos a tal vez, como lo decía Alfredo hace un rato, a las graves violaciones de los derechos humanos más visibles, y la primera de ellas es la libertad personal, y cómo el sistema de justicia se dejó en evidencia que, como se dijo anteriormente, no solamente no protege la libertad personal como un derecho constitucional establecido en el artículo 44 de nuestra Carta Magna, sino que también atenta contra esta garantía. ¿Ok? De hecho, en el 2017, conforme a informes de Amnistía Internacional, por ejemplo, el 90% de las detenciones cometidas en protestas sociales, en el contexto de protestas sociales, se dieron sin orden judicial. Simplemente fueron fundamentadas, o intentaron ser fundamentadas más bien, en el concepto de la flagrancia, ¿no? Que es una de las limitaciones a la libertad personal que establece nuestra Constitución, pero con una errática y preocupante interpretación, muchas veces haciendo uso de una fatídica sentencia de la Sala Penal que estuvo vigente en Venezuela casi 2 décadas, en la que se subsanaban las violaciones digamos, las violaciones que se enmarcaban dentro de una aprehensión, ¿no? Por parte de los cuerpos de seguridad, y una vez que llegaba pues al órgano judicial, estas falencias en la detención, estas violaciones en la detención eran totalmente subsanadas, ¿ok? Una cosa totalmente ilícita, y que, como lo dije, funcionó en Venezuela durante muchos años, y que ahora creemos que va a seguir, pero no sabemos bajo qué contexto, dada una reforma reciente del Código Orgánico Procesal Penal el año pasado. Según la misión de determinación de hechos, esto lo mencionamos en uno de los informes que hicimos para EPU, el juez penal, el juez de primera instancia, que está llamado a la protección de las garantías constitucionales, especialmente la tutela judicial efectiva, viola la libertad personal bajo en tres conductas distintas, ¿no? Una de ellas cuando omite revisar la legalidad de la aprehensión, ¿ok? Eso con relación a la sentencia que les mencionaba hace poco. En segundo lugar, cuando no emite una orden de excarcelación de manera oportuna, muy particularmente cuando la medida de coerción impuesta para someter al sujeto al proceso penal ya decayó, ¿no? Sea porque pasó el plazo establecido en la Constitución para someter al sujeto a un proceso penal, que en algunos casos es eterno, o sea porque el plazo de investigación que tiene el Ministerio Público también venció y no hubo una acusación fiscal o un acto conclusivo en este caso. Y finalmente, que es la situación tal vez más evidente y preocupante, que aun cuando el Estado tiene vestigios de querer proteger la libertad personal, ordenando la excarcelación de una persona que fue detenida de forma arbitraria o incluso también se da en casos de delitos comunes, el tribunal no tiene, o el sistema de justicia en general no tiene la capacidad de hacer cumplir esa orden. Porque como sabemos, y lo vamos a referir en dos casos puntuales, hay muchísimos ejemplos de situaciones donde se libra una orden de excarcelación y el órgano policial o el órgano de fuerza de seguridad no ejecuta la orden del tribunal, violentando, pues, entre otras, el artículo 5 del Código Penal, que establece, pues, la capacidad que debe tener el tribunal en ejecutar sus sentencias, ¿okay? Sus decisiones. Según uno de los informes del año pasado de Defiende Venezuela para el EPU, los fiscales, como miembros del sistema de justicia, desempeñaron un papel directo en casos que constituían detenciones arbitrarias, tomando las siguientes acciones, ¿no? Número 1, asumiendo posiciones a favor del gobierno. 2, omitiendo la realización de diligencias para perjudicar a las víctimas. 3, presentando órdenes de captura sin el cumplimiento de extremos de ley y en muchos casos presentando órdenes de captura posterior a la detención y el tribunal así acordándolas. Y 4, no asistiendo a las audiencias a los fines de dilatar o interrumpir los procesos. Incluso el año pasado, cuando se dio estas condenatorias express en muchos casos de asesinatos en protesta, entre ellos Daniel Kelly, Fabián Urbina, entre otros, estos mismos procesos judiciales en años anteriores constaban hasta de 20 sesiones diferidas por la incomparecencia, entre otras cosas, del órgano del Ministerio Público. Entonces esto determina que en efecto el rol del Ministerio Público ha sido determinante para ralentizar los procesos y evitar y asegurar, quiero decir, la impunidad de los perpetradores, ¿no? De los presuntos perpetradores. Entonces hay dos casos importantes respecto a esto que mencionaba de la ausencia del poder de ejecución que tiene el tribunal sobre su sentencia. Uno de ellos es el caso de los Polichacao. Esto fue un grupo de policías, de 14 policías que fueron detenidos en el año 2016 tras el homicidio del periodista oficialista Ricardo Durán. A pesar de ellos recibir una orden de excarcelación en prácticamente meses después de su detención, el tribunal no la ejecuta y estas personas estuvieron detenidas por lo menos hasta el año 2018. De hecho, hubo una fuga de 2 funcionarios policiales dado la imposibilidad del tribunal de cumplir esa sentencia, ¿no? Y de la autoridad policial en negarse a cumplirla, ¿no? Otro caso relevante también que hemos llevado en Defiende Venezuela es el caso de Anthony Vega, un preso político que fue torturado y que en el año 2018, cuando hicimos una petición ante el Sistema Interamericano de Derechos Humanos, esta persona llevaba 2 años con una boleta de excarcelación emitida en el año 2017. Lo que quiere decir que, al igual que en el caso pasado de los Polichacao, quiero decir, hay una insuficiencia por parte del sistema de justicia en cumplir estas órdenes, ¿no? En segundo lugar, otra de los puntos importantes que evidenciamos estos informes EPUS que enviamos el año pasado fue la falla en la investigación y en la sanción en lo que se refiere a la tortura. Ya Alfredo había hablado bastante sobre el tema de la tortura y su relación con las detenciones arbitrarias, pero nosotros que queremos resaltar que justamente esta falta de independencia y la presión política ejercida sobre los miembros del sistema de justicia es lo que ha perpetuado la impunidad, ¿okay? La Fiscalía en líneas generales, pues no promueve investigaciones ágiles, ni efectivas, ni diligentes, ni transparentes. Hay casos, numerosos casos, donde los detenidos que son llevados a los tribunales, que tienen evidentes síntomas de tortura, rasgos físicos de tortura, son enviados de vuelta incluso a el centro de reclusión donde fueron, o el órgano aprensor que los detuvo, ¿no? Pues obviamente poniendo en riesgo la integridad física y probablemente aumentando las posibilidades de que la tortura se extienda en el tiempo, ¿no? De hecho, el actual fiscal general, Tarek William, cuando ingresó al cargo en el año 2017, eliminó la unidad criminalística contra la vulneración de los derechos fundamentales. Es importante decir que esta unidad criminalística ayudó en muy buena medida a las investigaciones de los asesinatos en protesta en el año 2017, antes de la salida de la fiscal Luis Ortega. Gracias a estas investigaciones oportunas, en muchos casos se logró individualizar al menos al responsable material de los hechos. En otros casos no alcanzó para tanto, pero lo primero que hizo este fiscal al ingresar a la Fiscalía General fue eliminar esta unidad tan importante y que generó pues vestigios de justicia en su momento, ¿no? Para el año 2020, la misión de determinación de hechos, por ejemplo, determinó que en los 165 casos de asesinatos contabilizados en las protestas 2014, 2017 y 2019, solo 5 han dado lugar a condenas y sentencias. Esto no estamos contando las condenas express del año pasado, del año 2021, pero esto contabiliza un grado muy alto de impunidad, sobre el 90% al menos. Y respecto a la sanción que debe imponer el sistema de justicia a los hechos de tortura, también la misión de determinación de hechos, y esto fue reflejado en nuestro informe también EPU, no ha tomado medidas para garantizar que los órganos judiciales den prioridad a las denuncias de tortura. No hay evidencia, al menos emblemática, de algún caso que haya sido judicializado y condenado de tortura, de los casos que pues cientos de personas están constantemente evidenciando esta situación en el marco de sus detenciones principalmente. De hecho, nosotros en Defiende Venezuela tenemos un grupo de víctimas que pertenecen al FAVIC. 7 de ellos son víctimas de ejecuciones extrajudiciales, pero su núcleo familiar sufrieron hechos de tortura digamos, en el asalto a sus viviendas. Todas estas investigaciones, todas y cada una de estas investigaciones no han pasado de fase de investigación. O sea, ni siquiera hay una individualización de la responsabilidad penal de algún individuo del FAES. En ningún caso. ¿Ok? Y por último, también se evidencia una inactividad de funciones de la Comisión Nacional para Prevenir Torturas y Tratos Crueles, establecido en una ley especial que tenemos en Venezuela, y todas las funciones desarrolladas en el artículo 12 de esa ley. Es decir, desde la entrada de vigencia de esta ley en el año 2013, no ha habido un desarrollo de esta Comisión Nacional que se supone que está diseñada para prevenir la tortura y los tratos crueles. En Defiende Venezuela tuvimos varios casos también relacionados a temas de tortura. Tal vez el más relevante, para no extenderme, es el caso de Jeremy Lugo, que también es un preso político que se encontraba en el SEBIN. A esta persona lo golpearon, le aplicaron descargas eléctricas, para intentar lograr una confesión que lo vinculara a la oposición venezolana, particularmente un financiamiento de la oposición venezolana. Posterior a que se realizó la audiencia de presentación, donde aparece esta persona con hematomas, inflamaciones y heridas visibles, el juez no investigó las torturas y le dijo de forma extraoficial que esta persona no debía estar detenida. Y aún así, bajo este contexto, no se investigó esta situación que era visible en las audiencias de presentación. Y finalmente, el último punto que pudimos evidenciar estos informes EPU es la imposibilidad de la ejecución de decisiones de instancias internacionales, muy puntualmente de las medidas cautelares otorgadas por la CIDH. ¿Ok? Casos sobran a montón. Me referiré, por ejemplo, al caso de Román Tovar, Iniria de Ramos y José Humberto Hernández. En todos estos, estos casos de salud, ¿ok? El Estado venezolano no cumplió con su obligación de proveer las condiciones de salud para que estas personas obtuvieran sus medicamentos, y el señor Román y la señora Herida finalmente fallecen por la indisponibilidad de obtener estos medicamentos. Y el otro caso emblemático, referente también, que adelantamos en Defiende Venezuela, en litigio internacional ante el sistema interamericano, fue el caso de Ángel Viva, que aún a pesar de haber tenido una medida en el año 2017 y que fue extendida el año pasado, el general Vivas no continuaron, digamos, de una manera exponencial las situaciones de acoso y persecución por parte del Estado. Entonces, bueno, en líneas generales, estos son como los tres grandes rasgos importantes que nosotros podemos evidenciar del rol del sistema de administración de justicia en la protección, en la falta de protección a los derechos humanos en Venezuela.
Gracias, Ezequiel. Un panorama y un escenario bastante desalentador. Quisiéramos preguntarte brevemente, antes de pasar al ciclo formal de preguntas y respuestas, un poco, Alfredo también lo mencionó, Venezuela tiene todas las medallas de los países que violan derechos humanos, pero ¿qué recomendaciones podrían hacerse desde la perspectiva de la sociedad civil puntualmente a los estados de las Naciones Unidas que van a actuar en el examen periódico universal la semana que viene respecto de Venezuela?
Gracias, Carlos. Muchas gracias por tu pregunta. Las recomendaciones, digamos, han sido expuestas en múltiples informes, como lo dije inicialmente, ya nosotros lo habíamos reseñado en estos informes EPU. También las recomendaciones que ha hecho la misión de determinación de hecho en cuanto a la independencia judicial son importantísimas en tomar en consideración. Digamos, las medidas que pueden generar una mayor cantidad de expectativa van relacionadas a una eventual justicia de transición en Venezuela, que implique pues la participación de víctimas, etcétera, etcétera. Pero hay medidas que son, pues yo las denomino paliativas tal vez, que pueden ayudar a mejorar la situación de ausencia de independencia del Poder Judicial y por tanto protección a los derechos humanos de las víctimas, ¿ok? Una de ellas, por ejemplo, es salvaguardar las disposiciones contenidas en la Constitución, en la ley especial para sancionar y prevenir la tortura y otros tratos crueles. Estos son herramientas legales que están a disposición, que están vigentes en Venezuela y que no hay un cumplimiento efectivo de las mismas, ¿no? Por ejemplo, otra recomendación es exhortar al Estado en derogar la resolución 2703, publicada en la Gaceta Oficial 41.482, que dispone que todos los cargos de carrera de los funcionarios que presten servicio en la Fiscalía se transformarán en cargos de confianza, de libre remoción y nombramiento, ¿ok? También es importante crear programas de rehabilitación que respondan en cuanto a la tortura, que respondan a los efectos psicológicos de la tortura y otros tratos malos crueles, de conformidad al Manual de Protocolos de Estambul y demás instrumentos internacionales pertinentes. Podemos empezar de pronto desde la perspectiva internacional con ratificar el protocolo facultativo de la Convención contra la Tortura y otros tratos crueles. Esto es lo que refiere a la protección de este grave violación a los derechos humanos. Y también se pudiese implementar programas y talleres de capacitación para oficiales militares y policiales en lo relacionado a la detención y control de población penitenciaria. Obviamente mejorar la situación penitenciaria en Venezuela. Esto agudiza la situación de tortura que reflejaba Alfredo en sus comentarios iniciales, y yo creo que esto, entre otras recomendaciones, obviamente, que están visualizadas en estos informes, mejorarían la situación de protección de las víctimas ante el sistema de justicia venezolano.
Thank you, Ezequiel. Now we have still time for taking some questions from the floor. I will start with the same order that the presentations were made with Mariana. We receive then Alfredo and finally Ezequiel. So everyone in the session, feel free to let your comments or questions in the chat. We already have a few questions, so we'll be starting with this one. The pandemic found Venezuela in circumstances of economic and social devastation and authoritarian rule. What is the current situation with the COVID pandemic, and how has this further impacted an already failing justice system? please, if Mariana can make a comment about this, and then maybe Alfredo or Ezequiel, Alfredo and Ezequiel about this particular.
Thank you, Carlos. In my presentation, state as another manner to increase its authoritarian powers. Allegedly, the emergency state, according also with an already existing emergency state, the Venezuelan executive start to implement more measures to reduce the civic and democratic space and to increase the repression, criminalization, and to commit enemy. And as Alfredo comment on intervention, that can reflect as an excuse of the is that the increasing of the attacks against human rights defenders, against lawyers, against human rights and humanitarian organizations. Only in the last year, 2021, 743 attacks were documented against those people. More restrictions on the freedom of expression, on media, the new promulgation of laws according to terrorism, or topics about criminal law, and the increase of the use
I guess Mariana is having problems with her
of
connection.
violations. Sorry, I have an
Yes, Mariana, we lost the last 10 seconds of your comment.
all right. As I said, as I was saying, the last few years, we can see, and the different NGOs in Venezuela has documented how the justice system has a main role on perpetration of human rights violations in Venezuela, because the justice system is used to make reprisals against every person in the country who wants to vindicate its rights. So to conclude, the pandemic, in order with another legal and factual authoritarian measures, it served to allow the state to increase the impunity, to increase the repression, and to increase the criminalization in Venezuela. Thank you.
Thank you, Mariana. To add to that question, maybe Alfredo and Ezequiel can talk a little bit about the use of exceptional powers to further criminalize political opponents, and have you noticed any difference from the beginning to the pandemic back in 2020 to right now? Alfredo?
Well, yeah, I agree with what Mariana said, and well, we are in a dictatorial regime, so they use again the pandemic as many things, as other many things, and as an excuse to persecute people, and to, as you said, to use not just exceptional powers. I mean, they already have exceptional powers even before the pandemic. But it is important to understand two facts. Before the pandemic started, there still were protests in Venezuela, and they used the pandemic in order to control people on the streets and to basically to stop protests in Venezuela. Just to give you an idea, I travel around Venezuela many times by car, and because we have to visit not just victims, but also our team that is working all around the country. And just to go, for example, from Caracas to Guanare, which is in Portuguesa state, which is about 5 hours by car. I'm talking, you know, it's not too far from Caracas. You have to pass through 13 checkpoints, military or police checkpoints. After the pandemic, these checkpoints have increased all around the country. So there is, and they're using these checkpoints also for a political control. So they stop people. Sometimes there are bribes that you have to pay in order to pass through, but they detain people there without totally unconstitutional. So this is something that is a specific result of the pandemic. As I said before, we have a lot of restrictions. Actually, we haven't been allowed, for example, to get into the Helicoide or the HESIM, which is the Directorate of Counterintelligence, where many political prisoners are. And the excuse is the pandemic. And so again, yes, they have used the pandemic as an excuse to impose more restrictions. But even before the pandemic, there were restrictions. So, but yes, this is what I would say. This is a specific result of that. Of course, right now, it's been a little more opened. So courts are being opened. They were closed, I mean, the courts for almost 1.5 years because of the pandemic. Now they're open, so there are hearings. But still, the pandemic is being used as an excuse.
Thank you, Alfredo. And now, Ezequiel, in the same context, you mentioned several cases that's been in the main focus of the in general, the war, the COVID-19 pandemic. But on this case, you mentioned people who has died before the lack of attention in the jail. Have you any other experience to can share with the lack of protection of economic, social, and cultural rights?
Sí, yo agregaría a los comentarios iniciales y resaltaría tal vez algo que dijo Alfredo al final de su presentación, fue la inoperatividad de los tribunales durante aproximadamente 18 meses. Durante ese tiempo, no solamente no se celebraron audiencias de presentación a perpetradores de violaciones a los derechos humanos, sino que también las víctimas se vio reducida su posibilidad de interactuar con el sistema de justicia, muy particularmente con la Fiscalía de Derechos Fundamentales, que es el órgano llamado a investigar estas violaciones a los derechos humanos. También tenemos casos, reportes, donde presos políticos, como en efecto lo mencionaba Alfredo, no solamente no recibían visitas de sus familiares, en el marco de la protección a lo que implican los derechos de los privados de libertad, sino que el ingreso de dietas y demás enseres era limitado bajo el presunto contexto de que el virus se iba a transmitir en las comidas, ¿no? Entonces, esta situación obviamente debilitaba la integridad física como un concepto ampliado de la tortura de las personas que son detenidas por motivos políticos. Esta situación era extensiva también para los delitos comunes, para la población reclusa que se encuentra en estos centros de detención, aunque el sistema de justicia pudiese utilizar las herramientas digitales para darle celeridad a estos procesos, la situación era una total inoperatividad en ese aspecto. De hecho, la Sala Penal emitió una resolución a finales del año 2020 que habilitaba esta posibilidad para acelerar los juicios, y aún así, activada esta fórmula, solo se dieron muy pocos casos con ejemplos muy específicos de audiencias telemáticas.
Thank you, Ezequiel. Now, a general question for all the panelists. We have seen in Venezuela in last month the government with his the recent elected National Assembly back in 2020, at the end of 2020, has been reforming a lot of laws. For example, yesterday, the law about the Supreme Court, la ley del Tribunal Supremo de Justicia, but also last year, the Criminal Code, as Alfredo and Ezequiel mentioned it, and other laws related to, for example, the police service, the military courts, and several legislation related to justice system. So maybe you can make or share with the people any comments about how you can feel about these kind of reforms, how you valorate this, and what could be the political intentionality behind these reforms. We will start with Mariana.
Thank you, Carlos. Well, for many years, the Venezuelan state has been skillful in instrumentalizing actions in order to claim or to demonstrate to the international community its supposed and allegedly compliance with the international commitments. However, the reality is that if the systems and structural failures are not addressed, these supposed measures to make better the human rights situations are completely inefficiency and completely false. In between, the government and the regimes make this new modification of law and promulgation of new law, and allegedly to restore reform the justice system. Many human rights violations and many crimes against humanity continue to occur. The figures of many NGOs in Venezuela can show how the reality is that the Venezuelan state has not really intention to comply with its international commitments. And in between, they make this restructuration on the legal framework, also promotes new laws to persecute, to criminalize, to attack every person who by them are considered as enemies. So if the thesis of the internal enemy and the doctrine of national security continue to be implemented in Venezuela, and the peaceful demonstration continue to be repressed, the civil society continue to be criminalized, and the political prisoners continue to be in jail, in arbitrary detention, and suffering tortures. We cannot trust on the intentions of the state to comply with its international obligations on protect, promote, and guarantee human rights in Venezuela.
Thank you, Mariana. Now, in the same context of these reforms, Alfredo and Ezequiel, maybe you can elaborate about the relation with this, with the investigation by the ICC and the possibility of any other country starts a process under universal jurisdiction, and how this could be play in that board with the action from the government, but also with the action from the prosecutor to the ICC. Yesterday, everyone received information about this requesting to give Venezuela 3 additional months to present information. So how could you evaluate this process?
Well, of course, there is a total relationship with that specific opening of the investigation, or even before the investigation was opened, they were trying to present some kind of perception internationally, basically, that they were doing, I mean, I'm talking about the Venezuelan government, they were doing some kind of changes to protect human rights. But it's not just the opening of the investigation or the expectation that this investigation was going to be opened this year, but also the fact-finding mission reports that have specifically referred to human rights violations and violations of due process of law, etc. But also the presence here of representatives of the Office of the Human Rights, the Office of Bachelet in Venezuela, the UN Human Rights Office. I just want, but if you see, I mean, maybe someone will say, well, if they have made law reforms in order to protect human rights, as a first reaction, it will be something that you cannot oppose to it. I mean, it's positive in some way. The problem, if they are just cosmetic measures, or if they are real reforms, and practically if they're executing these reforms. I will give you 2 examples. They, as you said, Carlos, and also Ezequiel, there was a reform of the criminal procedural code last year. There is an article 231, that established specifically that no one can be on pretrial detention. So if someone is on pretrial detention for more than 3 years, even with an exceptional extension of 1 year, it means the maximum is 3 years, and they have to be released if there is not a sentence, even though it refers specifically to that. I already said in my presentation that there are, at this moment, 91 political prisoners with more than 3 years on pretrial detention. And it's not that they haven't done it automatically because the law obliges it. No, it's because we have required the courts to release these people, and we have filed petitions specifically for these specific cases, and they just have denied it without any explanation, or they haven't answered. So even though the law is specific, they haven't complied with the law. So they don't care about the law. So it means that the law is something more for the media and for the international community to think that they're doing something, but in practice, nothing has been done. Another example, and this is an important example because it was published in the media, and many international representatives of the international human rights institution actually asked me about it. There was a presidential decree that ordered the transfer of prisoners in general from the Directorate of Counterintelligence, the military Director of Counterintelligence, DGCIM, which is, again, the military counterintelligence unit. Well, at the beginning, they transfer about 20 people, but they incarcerate new ones. So there were new people at the Director of Counterintelligence, and there are still people there. So the decree shows, and they presented this decree as a, you know, as in some way, you know, reform on human rights, and as some way to, as a response to critique to you know, to different reports that said that people are being in this specific unit and they were tortured and all these kind of things, but the people are still there. There is, for example, the case of Maria Auxiliadora Delgado Taboski, who is in jail without trial, who is there. She's there just because they are looking for her brother, who is out of the country, and she's just there because they want her brother to come back to Venezuela, and she's there without the possibility to visit her, at least from NGOs like us. So again, this is more a cosmetic issue, and they use it again to present it to the media and to create this impact to the international community. And it is in some way effective, because they create the impact, and the people that don't live you know, the day-by-day situation in Venezuela, they believe that actually these people, the ones, I mean, this decree is being complied and people are being transferred from the DGCIM, for example, and this is not true. Or they believe, for example, that people are not on pretrial detention for more than 3 years, and they still are on pretrial detention. And that's actually what I can say about it.
Thank you, Alfredo. Now, Ezequiel, if you want to make some comments about the same topic, la relación entre las distintas reformas que han ocurrido en los últimos meses y los procesos de investigación en la Corte Penal Internacional, o si existe algún proceso o por algún potencial proceso de jurisdicción universal.
Gracias. Bueno, nada, yo suscribo muy buena parte de los comentarios de los ponentes anteriores. Nosotros, desde la sociedad civil, vemos con muy buenos ojos la apertura de una investigación ante la situación de Venezuela, dado que para las víctimas es digamos, la aproximación más cercana a los pilares de la justicia internacional, entre ellos pues la verdad, la justicia, la reparación y memoria. Las reformas que se implementaron el año pasado y que han dado continuidad el primer mes de este año 2021, el año pasado se reformaron 8 leyes en total, ya mencionamos alguna de ellas, tal vez la más emblemática era el Código de Justicia Militar, ¿okay? Que prohibía expresamente la posibilidad de juzgar civiles en jurisdicción militar. Esta situación se trató de evidenciar como una suerte de trofeo de que en situaciones pasadas esto ocurría y no era esta administración que lo hacía. Y esto evidentemente es mentira, es falso. Tal vez esta es la administración de justicia que más civiles ha llevado a jurisdicción militar. Respecto a la situación de la Corte Penal Internacional, nosotros desde Defiende Venezuela continuamente enviamos comunicados respecto a los delitos de detenciones arbitrarias y torturas. El panorama como lo dije al inicio, de las víctimas es alentador, exceptuando las víctimas, por supuesto, de asesinatos, quienes aún de momento insisten en que este delito pues sea incluido en la investigación de la Corte. Sin embargo, esto lo menciono justamente para hablar de que estas reformas, estas iniciativas que han tenido la Asamblea Nacional este año respecto a esta comisión para la reparación de víctimas como una suerte de maquillaje ante la ausencia de justicia en Venezuela, poco va a servir si la justicia venezolana no se sincera, si no hay investigaciones y condenatorias por lo menos a cadenas mandos digamos, de las fuerzas de seguridad del Estado. La inclusión genuina y verdadera de las víctimas en el sistema de justicia y la inclusión, por supuesto, y por supuesto quiero decir la reducción de las violaciones que ya, por ejemplo, Alfredo había narrado en cuanto al debido proceso, que se infiere muchísimo al acceso a una defensa privada, al respeto de los plazos determinados, al cumplimiento de las órdenes de excarcelación, entre otros. En líneas generales y como para concluir con una reflexión final, es decir, en la instrumentalización de la Asamblea Nacional como un método para hacer solamente reformas superficiales del sistema de administración de justicia no le va a ser de suficiente para evitar lo que sería la continuidad de la investigación en el contexto de una complementariedad positiva.
Thank you, Ezequiel. We have a lot of questions. I'm very sorry we cannot take all of them. We are in the final minutes of this session. But for a final talk or a closing remarks from our panelists, we have received several messages. Congratulations for the panelists and for your sharing your experience in Venezuela and for your work. So if you have to summarize what should be the main three things that the state's delegation should be know ahead to the UPR for the next week, what should be these 2 or 3 things that you want to the states present in the next session for Venezuela's recommendations or demands in relation with human rights? I will start with Mariana, after she with Alfredo and Ezequiel for these final comments. And thank you very much.
Thank you, Carlos. Thanks to all the attendees and my colleagues, panelists. The first thing that should be addressed is that in Venezuela, the lack of independence of powers and the absence of institution is a flagrant violation of international commitments and is presented as the starting point for committing human rights violations or for them to be on impunity. So in this regard, secondly, it's important that the states know that the justice system and in general the entire institutional apparatus of the state are the executing arms of the repressive policy of the criminalization of the social control on an authoritarian regime. And it's important to call upon their responsibility for these measures to be taking the necessary steps to stop that violation of human rights, reaching the higher consequences, investigating and punishing those who by action or by omission are responsible, but not only the material authors, also the intellectual authors and all the responsibles and the perpetrators who design the repression system. And last but not least, the international community must continue to follow up the situation in Venezuela and continue to take strong actions that contribute to achieve the justice that Venezuelan population needs. Thank you very much to all.
Yes, well, as a first point, I will suggest to them to refer to the use of the judicial system as a weapon for political persecution, but more specifically, the existence of 91 political prisoners on pretrial detention with more than 3 years in jail, and the existence of more than 50 of them also with more than 2 years on pretrial detention. So the pretrial detention as a way of keeping these people without trial and also as a method of torture and as a way to put pressure on them to admit crimes is something that's being used systematically in Venezuela, and more specifically in the case of political prisoners. Another important thing is the investigation, the lack of investigation of cases of torture. In the case of Foro Penal, we have denounced to the prosecutor office many cases of torture without any response. And this is something extremely important, because of all these 16,000 political detainees that have been in prison or detained since 2014, about 50% have denounced that they are being tortured. And as a third point, I think it is important to refer to the persecution of human rights defenders. So this is something that actually increased the last year with the case of Azul Positivo, for example, 5 members of this organization that were detained, and they're still with precautionary measures. They're still, even though they were released, they're still with the restrictions, freedom restrictions. And the case, other cases also, actually there was a case of our coordinator, Orlando Moreno, was detained in Del Tamacuro, Foro Penal, coordinator Foro Penal, but also the case, a recent case, a very important case of Javier Tarasona. He's been more than 6 months in jail for denouncing human rights abuses.
Thank you, Alfredo. Ezequiel, tus comentarios finales.
Gracias, Carlos. Bueno, mira, creo que el inicio es sincerar, en efecto, las investigaciones de violaciones graves a los derechos humanos, iniciando, por supuesto, como lo decía Alfredo, con los casos de torturas, que es tal vez lo más emblemático en cuanto a la ausencia de respuesta del sistema de justicia ante estos casos. Por eso nosotros consideramos que desde Defiende Venezuela se debería implementar un programa de protección de víctimas, de testigos, que permita salvaguardar la integridad de las víctimas de tortura y asegurar la rendición de cuentas por crímenes de lesa humanidad. Eso es una muy buena iniciativa a los fines de fomentar la investigación de este grave flagelo, ¿no? Lo segundo pudiese ser llevar a cabo investigaciones, como lo dije, exhaustivas, imparciales y oportunas de todas y cada una de las denuncias de tortura, evitar malas prácticas judiciales, como es el retorno del detenido al centro de detención donde están los custodios que en efecto están ejecutando las torturas. Y finalmente, pues creemos importante que dentro del sistema de justicia hay un renglón que es el sistema penitenciario, que durante muchísimos años, durante varias décadas y especialmente estos últimos 15 años, se ha agudizado el problema de hacinamiento, el problema de imparcialidad y arbitrariedad en cuanto a traslados no acordados, en cuanto a el sistema de corrupción que implora dentro de estos centros penitenciarios a los fines de garantizar la seguridad física de los presos comunes y por supuesto los detenidos de formas de pensamiento. Entonces creemos que mejorar el trato al prisionero, reformar el sistema penitenciario por una forma genuina que incluya a la sociedad civil y a los expertos en esta materia, es un paso importante a los fines de obtener, por supuesto, o disminuir los niveles de impunidad en los casos de violaciones graves a los derechos humanos.
Gracias, Ezequiel. Thank you very much, all the panelists, for this conversation, and thank you all the people who share with us this time to understand and learn more about the situation, about the lack of independence of the judiciary in Venezuela. The people who maybe it's interested in this can keep following the social network of the organizations, Centro de Derechos Humanos de la Universidad Católica Andrés Bello, Foro Penal, Defiende Venezuela, but also the organizations who promote this event, Robert F. Kennedy Human Rights, Fair Trials, and the International Commission of Jurists. of course, keep in mind the movement of the Venezuelan civil society in Venezuela the next week for the Universal Periodic Review. Of course, thank our panelists and our interpreters, and thank you all. Apologies again for we cannot take all the questions, and thank you very much. This the recording of this event will be available on YouTube in the next days. So thank you very much and goodbye.